Okay. This is Grow Michigan versus Michigan State University Federal Credit Union et al., docket number 20-469CB. And this is the time set for hearing on MSU-FCU's motion to allow deposit of disputed funds with the court and to discharge MSU-FCU from liability. And if we could start with appearances, please. I don't know what order you
Sure.
want to go in.
Scott Chernich and Brandon Schumacher for MSU Federal Credit Union.
Your Honor, Michael Perry and Amy Molanen for Elfing Corporation and GSEIAS.
Okay, thank you. And then who's arguing this for MSU? You, Mr. Chernich?
I will, Your Honor. Thank you.
Okay, go ahead.
Yeah, sure. I know the court's familiar with this case. In fact, there was a very similar motion brought by Grow some time ago. As a result of that motion, I don't want to say the court invited MSU to file this instant action motion, but at least I interpreted it that way. So in an effort to resolve this case for MSU, being the innocent third party here is I want to say the Marvin in the middle, but we're the ones that are stuck with the money, and two different entities want it. Grow Michigan believes it's entitled to it, and Alfing and or GSEIAC believe they're entitled to it. It's a classic situation in which the interpleader statute and or court rule contemplates that the court, when we're faced with having double liability, that the mechanism to resolve that is to tender these monies into the court or otherwise preserve them by some other mechanism, and until the court can determine who these monies belong to. Importantly, I think this is it's important to point out that this is a little bit different, or not your typical credit union relationship with its member. This is a pretty complicated business loan transaction that has been going on for some time. And important to all of that is understanding that what really caused MSU to be in the middle here is that monies were deposited into GSE's account at MSU Federal Credit Union. Alfing says it was by mistake, so does GSE. The problem with that is that under the intercreditor agreement between MSU Federal Credit Union and Grow, we were required to hold those monies in trust and tell them about it. So as soon as we were informed of the deposit and the request for the money back, we had to turn to Grow, with which we had a contractual relationship, and tell them about this. Once we tell Grow about it, they say, don't send the money to Alfing. So this is classically where we're stuck in the middle and subject to double liability here. And I'm happy to answer any questions you might have.
I don't have any. Mr. Perry?
Yes, Your Honor, thank you. I think it's extremely interesting and telling and frankly determinative of today's hearing in that Grow failed to appear, failed to file anything in opposition to our argument, which pointed out quite correctly that Grow has no legitimate viable interest in the money, that the only claimant with a legally protected interest in the money is GSEIAS. Grow has essentially conceded that by failing to appear here today and by failing to file anything in response to our argument. Zero. In any event, if I have to proceed with the merits, the essence of our argument, Your Honor, as you know, is that interpleader is inappropriate here because MSU-FCU does not face double or multiple liabilities for the money at issue. I just noted how Grow has failed to respond to this motion. I've incorporated and adopted by reference our pending summary disposition motion in brief, which clearly illustrates Grow's lack of an interest in the money. The court has already found that Grow could not file its own interpleader, and that its prior motion was in effect a impermissible attempt to seek a prejudgment writ of attachment. I've also pointed out in the brief, and there's no argument to the contrary from GROW or FCU, that GROW itself has failed to claim that MSU FCU violated or was in breach of the intercreditor agreement. It's not made a claim against FCU for specific performance of that agreement. It's not sought MSU FCU to turn that money over. So this claim that FCU faces multiple liabilities is specious at best and is clearly belied by the record here, Your Honor. And if we have to get into it, and again, there's been no response by GROW or FCU to this, the money in question is not, quote, proceeds of any transaction subject to GROW's lien, because at best it arises out of the alleged use of an asset. And first, I'd note that Ms. Emfield has attested to the fact that there was no use, but even hypothetically, if there was a use of an asset, money realized from the use rather than the disposition, i.e. sale or lease of an asset, is not, quote, proceeds under Article 9 of the UCC. The loan agreements do not define proceeds in any other way. In fact, they don't define the word proceeds. So we have to look to the statute. The statute doesn't use the word use. It talks about disposition. And again, there's been no response from FCU or GROW to that argument which we've made. So for all these reasons, we would ask the court to deny FCU's motion. With regard to the discharge from liability aspect, when there's no impoundment or in order to deposit or hold funds, the subsection of the court rule providing for discharge of liability is inapplicable. So I would ask the court, in addition to denying the motion to deposit funds, deny the requested for relief to discharge FCU from liability, in regard to the fact that we have made, on behalf of our clients, a cross-claim for conversion. I received about 20 minutes before this hearing began, maybe half an hour, FCU's response to our summary disposition motion, which is pending next week. And again, nothing received in response to it from GROW. The FCU argues that we are effectively seeking summary disposition on count one of our cross-claim, which is for conversion. That's not what we're seeking. We're just seeking an order that does not discharge FCU from liability for wrongfully holding that money. And FCU has admitted that it has no right to hold the money. So I would ask that the court both deny the motion in whole, and in particular, order FCU to immediately deliver the money to my client. And I'll take any questions the court may have.
I don't have any. Mr. Chernich, did you want any rebuttal time?
Just briefly, Your Honor. The last statement by Mr. Perry is entirely inaccurate. We are subject to double liability because he's asking for and has sued MSU Federal Credit Union. And we've got the contract that we attached to our motion that demonstrates we've got a contractual obligation with GROW. They may not have sued us yet because we didn't give the money to Alfing Corporation, but they sure as heck have told us they're going to. So I think the term specious applies to the arguments of Alfing and not MSU Federal Credit Union. Thank you.
All right, thank you. Well, I believe that Alfing and GSC are jumping the gun a little bit here. They claim that GROW has no viable interest in the funds, therefore MSU FCU isn't exposed to double liability arising from its possession of the funds. But I think Grow is making a claim. They didn't respond to this today and they didn't appear, but there's a summary disposition set for next week. And I think Grow's claim, and it's not directly at this point against MSU FCU, they're claiming that GSE Machining transferred the collateral from Grow's loan to GSE IAS, and GSE IAS used the collateral to obtain the work from Athling, and therefore the Athling invoice payment rightfully belongs to Grow. That claim, again, by Grow is the subject of a motion for summary disposition set for next week, where Athling and GSE IAS are arguing that Grow lacks a legally cognizable interest in the funds. And I'm not going to conclude that Grow isn't going to respond to that motion for summary disposition like they didn't respond to this motion today, because the deadline to respond hasn't passed yet. And I'm certainly not going to rule today with the summary disposition pending for next week that Grow has no viable interest in the funds. Now, I realize that Grow currently has no claim against MSU FCU because the only count in Grow's complaint that pertained to MSU FCU was the failed interpleader count. But if Grow were to prevail on its claim that the funds rightfully belong to it, then I think that MSU FCU could very well be exposed to liability if it gave the money back to Athling and GSE IAS. So, and I would note as well that the court rule, interpleader, and the requirements of interpleader don't require that there be an existing claim. It's a risk of liability that it recognizes as sort of protecting against. So on the other hand, Athling and GSE IAS have actually filed a cross-claim against MSU FCU for conversion. So I think that does put MSU FCU in the classic position that interpleader was intended for. They're holding money that they don't themselves claim any right to, and they have potential liability on the one hand, if not an actual claim filed against them on the other hand from two different entities. So I am going to order that the $108,469.80 held by MSU FCU, into which they claim no right, be deposited with the court until such time as a determination is made as to which entity it belongs to. That could happen next week at the motion for summary disposition. I don't know, because I'm not ruling on that yet. And again, I'm waiting for a response from Grow. And maybe it won't happen next week at the motion for summary disposition, but I think it's appropriate at this point to order the money that MSU doesn't claim any right to be deposited with the court. However, I am denying MSU FCU's request to discharge it from liability in the face of Athling and GSE IAS's cross-claim for conversion. And, while I recognize on the one hand that interpleader is sort of what that is supposed to protect against by saying, okay, pay it to the court and, we'll hold it until we figure it out. There has been a time lag here, and I'm not deciding on anything. I'm not ruling on a conversion claim. I'm just noting that MSU FCU received the funds on July 16th of this year. It didn't file for interpleader protection until September 24 of this year. So in the interim, or not really in the interim, but on October 1st, we had the conversion claim. So I am not going to, that's still pending, and I'm not going to grant the request to discharge MSU FCU from liability. So, who wants to prepare an order that reflects all that? Or did you attach one? Wait a minute, I think someone attached one.
I think we each did, Your Honor.
Okay, I can find Mr. carries. And they're probably both not completely accurate, I'm gonna guess. They're not. Okay, so I'm just gonna take MSU FCUs and cross off the last paragraph that pertains to the discharge from liability. And hearing no loud complaints, I'm signing that version.
Thank you.
Thank you, Your Honor.
Okay, I will have this filed with the clerk, and they'll send out copies of you to you, I presume.
Thank you very much. Thanks
Thank
for your
you,
time
Honor.
this afternoon.
Thank you. That'll conclude our hearing.